So I'm here with Terry Gorry from Terry Gorry Solicitors. So for those of you who don't know Terry, I first come across him when I first moved to Ireland 7, 8 years ago. So I was doing a bit of development in the UK at the time. I would have been working with a good solicitor, but when I moved over this side of the water, I didn't really have anybody to fall back on and I suppose take on board stuff from a technical point of view. So I started reading some of Terry's books, watching his YouTube videos, and obviously just thought it'd be a good idea just to sit down and catch up today, just to have a conversation. So Terry's done a bit of property development himself in the past, which we'll talk about in a second. And now Terry is a solicitor, advising predominantly, is it self-builders, developers, a bit of everything you were saying?
A bit of everything, but mainly your ordinary Josephine buying their first property or whatever, and obviously selling as well, trading up and trading down and so forth. And then you have the likes of probate sales and so forth as well, you know. Then we do a bit of stuff in relation to commercial, with obviously small business owners, either buying investment properties or maybe taking leases on commercial premises and so on.
Okay, I'm with you. So the big part of, I suppose, what I want to try and get into today, I'm always harping on about the need to do intense bank rate due diligence before you buy land or property. I think one of the things that I see people falling short on, you know, it's not just build costs or buying the wrong property in the wrong places. It's just making sure, is doing, people not doing due diligence and taking a risk on maybe the title or the security of any property. So just look in terms of developers or self-builders that come to you, ideally what process do they expect you to go through, or what would you generally go through?
Key thing to be identified at the outset is whether they're borrowing money from the bank or not. Because if they're borrowing from the bank, then I need to certify title for the bank, and I need to ensure good title for the bank. And good title is a particular standard of title. And even if my client who's borrowing money is anxious or willing to take a chance, take a punt on a particular site or whatever, I don't care, because there's a third person in the relationship, that's the lender.
Yeah.
And I have to make sure that I get good title for the lender. So I may point out a difficulty with, for example, a septic tank, sewerage services, road abutting, etc., not being in order, or a question mark, boundary dispute, or an issue with next door neighbour or whatever. I need to put them on notice and if the planning, for example, wasn't in order, I'll have to contact the bank and say, look, there's an issue here. I want to qualify my title. Now, the buyer, if it's a small developer or an ordinary person, might say to me, look, I'm happy enough, I'm prepared to take a chance. But I can't take a chance because, as I say, the third party in the relationship is the lender. Yeah. The lender, remember, has the money. So if the money is not advanced, there's no deal. On the other hand, if the person is a cash buyer, and we come across plenty of cash buyers, funnily enough, then they can take a view themselves. You know, you're going to warn them, obviously, there's a problem here or there, or there's a problem with the septic tank, or the septic tank is in the premises, all right, but the percolation area is in the field next door.
Yeah.
And maybe the farmer next door is going to have you over a barrel when it comes to cleaning it or emptying it and so on. So that's the sort of stuff you need to be very, very careful about. So you're looking at good title, and you're looking at planning, and you're looking at the services. And services are key. That's water, sewerage, and the road abutting the property. Because if the road abutting is not in charge of the local authority, then you need to be sure that you're not landlocked. You're not buying a landlocked property. Yeah. You're not buying a property over which there may be a claimed right of way, but it's not established, or it's not registered, or there's going to be a dispute or a row with a neighbour.
Okay, so look, ransom strips, that's all.
Ransom strips, and you're over a barrel, you've bought the bloody property, and the next thing is the neighbour is out with a tractor or whatever, blocking the little boreen, saying there's no right of way there, this is only for my use or for agricultural use or whatever. So the likes of that is absolutely key. Everything else is down to the punter themselves. They can take a chance if they want, but we have to get good title. And good title comes down to, as I said, good title, the ownership, that the person has the authority to own and sell the property, planning, and the services then be key.
Okay, I'm with you. Just on, because a big one I look at is access. Yeah. Making sure that any access routes are taken in charge.
Yeah.
Have you come across any issues with that previously, whereby somebody's purchased maybe land or property and they couldn't actually...
Yeah, we have a couple there at the moment, actually. One is where we're buying, and it transpires that the house which we're buying, there's a piece at the front of the house, piece of the garden, which is supposed to be reserved for future road widening for Kildare County Council, or
Okay.
and we're not sure exactly how much they're going to take or whether they're going to take it.
Was that like a compulsory purchase over the time?
It might be, but it mightn't be, because to be honest with you, it was granted, the permission to build the house was granted, and there was a condition of that a little bit at the front be reserved. So the county council may well argue that this is part of the planning conditions, and there's no CPO and you won't be paid for it.
Okay.
Because we granted you the permission, remember, and you built a big mansion of a house, and that's a condition. So they may not get compensated. There's a question mark over that. We need to establish it. Then we have another house locally there where there's a question mark over leak and access to it, without disclosing too many secrets. It's to do with Waterways Ireland and the canal.
Okay.
So you can access canals, and you can cycle on your bike, and you can go walking and recreational and so on and so forth on the road beside the canal. But there are some houses built on the canal that the question arises about access, etc. And access there is actually owned by Waterways Ireland. So again, you might have an issue in relation to maybe getting a right of way or something. So that's the sort of stuff you might take it for granted. Oh, that house is there 50 years or 100 years. Of course, we have access, but the legal position is it mightn't be so clear anymore.
Okay. Then you'd obviously require a certain type of access as well. So access at all times for all rights.
Absolutely, yeah, access to come and go, but more importantly, either a grant of right of way from the owner of the land over which you're accessing it, and that may well be Waterways Ireland. Now, there is a procedure or a process by which you can apply to Waterways Ireland to get a grant of right of way to your property or whatever, but it can be slow enough.
Okay.
It can be slow enough, and sales can fall through as a consequence of the question mark over the access, or if it's not resolved, or if the property was put on the market perhaps prematurely,
Okay, I'm with you. I actually had a client get in contact a few weeks ago. They purchased the property, and they worried that the planning approval didn't accord with what actually had been built on site. And my answer was, that's not really something that I do. So in that instance, what's your process? What do you actually do?
Process is very straightforward. The solicitor acting for the purchaser there has to ascertain that there is planning permission in place for the development that was carried out, and B, that there's a certificate of compliance with planning permission and building regulations from an architect with insurance.
Okay.
That's the process.
Okay.
If we get those two, that's the golden ticket. It's like we walk around the chocolate factory, but if we don't get those two, then there's a steward's inquiry. Then we're saying, look, what's the story with the planning? What's the story with that extension out the back, etc. Okay. And sometimes other solicitors may be misled by their clients who say, no, I didn't carry out any development. And then when my client goes and gets a survey carried out, the survey may make reference to the shoddy extension out the back and has a planning permission. And, it's only now becoming apparent that there's some work carried out, etc. But it only becomes apparent when there's physical inspection carried out.
Okay.
Do you know what I mean?
Yeah, no, that's the thing.
So from a legal perspective, the other solicitor, in good faith, is acting on his client's instructions and saying, no, there was no development carried out except for the original planning permission, adheres to permission.
Yeah, because it can get quite complex, can't it? Because with many properties, you can have many planning conditions.
Absolutely, yeah. You could have many developments as well. I mean, over a period of time, over the course of 20, 30 years, people build all sorts of extensions, and some of them require planning permission, some of them don't require planning permission, some of them are exempt. But, from a solicitor's perspective, you need to be absolutely clear what is the story about planning, because planning is one of those things that, in order to give good title to the lender, it must be in order. Because if it's not in order, then it's going to be difficult to sell it. And if a bank, for example, had to foreclose, repossess the property, they're going to have a hard time selling it if the planning is not in order. And they're going to come after me then on foot of my undertaking to get them good title.
Okay, I'm with you. And what about the stuff like the pre-63s? Would you do a lot of that?
Yeah, a lot of property actually in the last few years since Brexit. Actually, a lot of UK people coming over here, buying bits of properties in the west of Ireland, especially for $100,000 or thereabouts. Yeah. A lot of them are pre-63s, and they are hoping to do them up themselves and living them mortgage free. So that's the plan. And a lot of them, as I say, have come here as a consequence of Brexit and that sort of thing,
Okay.
So some of them might be working from home, and they'll be more concerned with good Wi-Fi rather than, a lot of other stuff. But some of them then do the hobby thing with, doing the place up. And some of them even have started YouTube channels, name like Life and everything or whatever.
Yeah, thing.
And so at least from Cavan, whatever, Sligo, Mayo.
Okay.
But some of them then have bailed and gone back or cleared off because the dream wasn't, the dream is the dream. So.
Okay. Just on the pre-63, for people who are like new to this type of stuff, how do the regulations rate those properties?
So the planning laws only started in the 1st of October 1964. So anything that's pre that, that's the commencement of planning legislation in Ireland. Anything that's prior to that doesn't require planning permission. So if you're buying such a property, like an old cottage or whatever, you might get a declaration or a statutory declaration from the vendor or the predecessors to say that the property is pre-63. If that's the case, fine, you know.
Okay.
But you don't want to see a fucking big ass jacuzzi out the back or something, extension or something like that.
Yeah.
Because clearly, this is 1980 or 1990s development and we need planning for that. Unless it's exempt. Maybe exempt, but if it's exempt, we need a certificate from an architect to say it's exempt. It's not good enough for the vendor to say it's exempt.
A minute. And what about the stuff that's built between, is it 1964, isn't it, and 2040 when the building regulations came into effect?
Yeah, so the building regulations that come in from 1990.
Okay. Were they amended BCAB regulations?
Well, amended ones may have come in after that, but yeah, I mean, again, we're looking for two certs generally in relation to when we're buying any property. A cert of compliance with building, with planning permission, and a cert of compliance with building regulations.
Okay.
And again, the same architect may do both, that's fine. And if there's a development or an extension done or some development down through the years done, again, we're looking for the same two certs, building regs and planning permission.
Yeah, of course, yeah. Okay.
And all new developments will have the same thing, but there's a new system there now, the BCMS system now, where they upload the building regulations onto this BCMS website and so on, the new developments. But that's what we should be checking and concerned about stuff like that. The certs are important.
Okay.
And the search from a qualified person, an architect with professional indemnity insurance is equally important,
Okay. What I'd see quite a lot of is people coming to me with a property maybe that was built in, say, 1995 or 2000, wherever it might be. It's not compliant with modern day building regulations. And they'd be under the impression that they can jazz up the building, make it look nice without maybe having to comply with Part B or Part F or, whatever.
They might be able to now, but in fairness, anything that doesn't comply if the regulations have changed, you're not obliged, I don't believe, to update it, but any new development you do has to be in accordance with the current regulations, you know what I mean?
Yeah.
So it is possible that you buy a house, if it's compliant with regulations in, say, 1995, 1996, the regulations have improved, but the planning documents and the regulations, building regulations documents are in order if it was in accordance with the regulations at the time.
Okay, I'm with you. See, what I thought might be an issue from down the line, sort of thing, is if I bought that property and then I wanted to sell it in time to somebody who was looking to take out a mortgage, and going back to what you said at the start, if I was a lender coming in, I'd want to know that property was built in accordance with building regulations.
It is, but it must be built in accordance with the regulations at the time.
Okay.
And the Law Society practice direction is that it would be unreasonable to be looking for the regulations of 2014 to be applied to a house that might have been developed in 1985. You know what I mean?
Do you ever see people having problems getting mortgages on those properties? Because obviously they're not.
Yeah, they can. Yeah, absolutely. And to be honest with you, what a solicitor will do is he has to give a solicitor's undertaking to the lender. But what he might do is he look to qualify his undertaking. In other words, what we do is we write to the lender and say there was a development carried out in 1970. There was no planning permission applied for. To nothing we can do about it. The local authority hasn't taken any action. Are you happy to proceed? If they say yeah, go ahead, I'm covered. You know what I mean?
Okay.
But I'm going to check first. So I'm going to qualify my undertaking to the extent that I'm saying there's defect or an infirmity with this property. Are you happy to proceed? Because remember, I'm not putting my balls on the line, quite frankly.
Yeah.
Do you know what I mean? So they have the money and they're going to give it to me. But I'm being upfront with them and saying, look, there is a problem. It's not perfect. And most of the time they will accept it. Sometimes they say, no, we're not, accepting that or whatever. Now, you could have a big attic conversion done and it's a bloody fire hazard, or there's 3 or 4 bedrooms in it. And I mean, if the house is being valued on the basis of being a 5-bedroom house and 3 of them are basically unlawful, or you know what I mean, then the bank will balk and say, no, I'm not touching that. It's fair enough.
Yeah, no. Okay.
Well,
I suppose that brings us nicely on the bid X1. I know you do a lot of stuff for other clients, don't you? So carrying out pre-purchase or
I do. There's the legal packs available online for all those online auction houses, BRG, Gibson, Bid X1 and so on. And it will be vital, very important for anybody who's going to buy to get the legals checked out.
Okay.
without that, I mean, as I was saying to you earlier on there, I've seen some horror stories, and one in particular would be to do with sitting tenants. An awful lot of the houses that are being sold now are receiver jobs, they're repossessed jobs, they are investors who were unable to pay back, and the receiver will just say, look, we're going to sell this thing. There's a sitting tenant there. We know nothing about him. He won't even open the bloody door to us. He has a big dog, and so we're going to sell it with the sitting tenant. Okay. So you might come along and say, okay, I'm going to take a punt on this. I'm going to take a chance, and I'll be able to get him out or get her out, whatever, or whatever. Okay. But you need to be aware of that at the outset. So, that's why you want to get your due diligence done and get the legal pack checked out before you bid at a bid expo. The bottom line is, hammer comes down, you're on the hook, you pay your deposit, and it's gone. So you can't complete the sale, you lose your deposit. But not only do you lose your deposit, from a legal perspective, they could actually sue you for the balance.
Okay.
Now, they don't often,
Yeah.
because they might say that you're a busted flush, you know what I mean? And they might just take the money and sell it to somebody else. Okay. But when they sell to somebody else, they can actually sue you for the difference.
Okay.
If they want as well, you know what I mean?
Yeah. Have you ever seen that happen? Or?
I did. I saw it happen once, yeah.
Okay. The just for people who've never lifted stuff at bid X1 previously, or they're a bit unsure, why does a property generally end up there? Is it just because there probably is something wrong with it, or is it usually just easier for them to do?
Generally, it's receiver sales, and generally it is easier and it's functional or practical to put them up for auction, and you will have people, speculators, opportunists, investors with cash who will buy these properties and redo them, maybe bring them back to the market later on. But they are distressed. But as I say, the receiver acting on behalf of the bank needs to get cash in, and if they bought the debt for small money, they're perfectly happy to let it go at an auction at what appears to be a reasonable price, and they're covered. And the punter might get a bargain. Now the punter could get a kick up the ass if he doesn't, if he's not careful.
Yeah.
Especially with a sitting tenant, because sometimes sitting tenants can be very difficult to get out. Now I've seen some work out, I've seen some not work out.
Aside from sitting tenants, what's some of the horror stories you've come across with those type of properties?
Disputes and litigation, threatened litigation. Then some people, to be honest with you, who have been dispossessed or have lost the property, they sometimes will try and scupper the auction by sending in either letters, solicitors' letters, or they'll even commence legal proceedings to try and scupper the whole thing and try and ward people off, etc., etc. A lot of the time these things are bluffs, but sometimes they're not, so who knows? So obviously you'll have to advise your client if they're looking at such an auction, say, look, there's threatened legal proceedings there. I don't know whether they're serious or not, but you need to be aware of it.
I was actually looking at one of those for a client a few weeks ago, and I wouldn't be too bad in terms of reading the legal wording, but even some of it was just double Dutch to me. I didn't have a clue what I was reading, so...
I have a client who actually buys a lot of bid X1s, and he's done really, really well. Now, he's taken a lot of chances, but he has done really, really well over the last, say, 12 months or so. But I did see one in particular, he contacted me in a panic a few days before the auction. There was a letter gone in from a solicitor or from a dispossessed owner or whatever, threatening high court proceedings, etc. And he said, what am I going to do? I said, look, it's your call. I don't know what to do. They might be just bluffing. And as it happened, they were bluffing, because he bought the property, he's flipped it like 3 months, 6 months later. He's done really well, But you never know.
No, you don't.
And you could get dragged into a sort of a legal situation where, you might end up spending the money on legal costs that you could avoid by just buying that property, but there's no controversy,
Okay. And I know it's a matter of, is it buyer beware?
Absolutely. Yeah, absolutely.
But the seller should be bound to provide all information that they have in their possession, or do you find sometimes they're holding stuff back?
No, they do. In fairness, the receiver does, but I mean, they actually put all their cards on the table, face up, and they say, this is a pile of crap, or this is a decent house, or this is a decent property, but here's the problems or imperfections with it. We're putting you on notice, and you're buying it with all this crap, and you need to carry out your own due diligence and research. And they do that because they cannot have people coming back to them then saying, oh, you never disclosed about this, that, or the other. So they actually are, to be honest with you, clean enough in that respect up front. And they'll say, we know nothing about the tenant, we know nothing about the sewerage, the water, or the road adjacent. You can carry out your own due diligence. Okay,
Are they actually
do that?
Yeah.
But sometimes, I mean, you could drive by. I mean, the likes of here. This is obviously the main body road. So anything on this road is in charge of the local authority.
Yeah.
So, but even a receiver selling this property, for example, here, If it was a receiver sale, he'd say, we know nothing about the road, we know nothing about service. You know what I mean?
Yeah.
Even though it's evident with a basic knowledge that the services are abutting here and the road is abutting or whatever.
Yeah, it's almost in their interest to give you as little information as possible that you make your inquiries. Look, I was only asking, it was a few years ago, I got stung, it was in Wales. We were purchasing a site that was full of Japanese knotweed and it was made great, but we weren't given an opportunity to do a great investigation. So, the client had already done that because the trials were apparent.
Yeah.
They didn't disclose our information until after we got from the process. So that's what I was asking. I wasn't sure if those, I suppose with the BidX properties, a lot of them might have existing condition surveys on the existing structures.
No, generally there's no surveys, and generally the contracts are drafted in a way that it's very much the receiver saying, we have limited information, we have a limited knowledge, buyer beware, you buy it as it is, we're not taking anything away, there's no contents, but if you find a pile of crap out the back, it's your baby, you know what I mean? They do nothing, and that's it. And you kind of know that up front, and people who are experienced at it will recognise that.
Okay, I'm with you. And will they ever give you an opportunity to go in and do a survey if you'd like?
Or you can do a survey if you want, that's provided you can get access. Now obviously the ones with no sitting tenants, there's no problem. You can do a survey.
Okay, I'm with you. I see a lot of developers at the moment, they're looking to go down the HMO route. Do you see a lot of people doing that? Do you get involved in that type of thing?
HMO.
Houses of multiple occupation. So it's
Houses of what?
houses of multiple occupation. So it's effectively you might take a 3-bedroom house, might have several rooms downstairs, and turn that into a 5-bedroom property. And I read the rooms out individually, but there's no building regulation or guidance on that at the moment. So people,
it's kind of a grey area, and it's a grey area in terms of the Residential Tenancies Board then as well. Simply speaking, there is a particular piece of the Residential Tenancies Act which allows a person who's renting a room or renting a property on the licence to actually apply to the landlord to be recognised as a tenant.
Okay.
And to have all of the rights that a tenant has. And if the landlord is not agreeable, they can go to the Residential Tenancies Board.
Okay.
So I have come across people who have big houses, let rooms individually with licenses, etc. But I'm not sure whether that's the silver bullet from an investor's point of view or not, because things could go wrong. As I say, if individuals do come along and bring claims to the RTB saying, I want to be recognised as a tenant, it's possible that it succeeds.
Okay. I know.
No, it's not guaranteed, but it is possible. But I did see a case there a few weeks ago where somebody renting a room in a house from a sub-tenant were not given the protection of the Residential Tenancies Act because they didn't fall within the Act.
Okay. I'm with it.
In order to fall within the Act, as a matter of interest, the accommodation should be self-contained.
Okay.
Right? So a room on its own in a house is not self-contained because you have to go out to the bathroom or the kitchen.
Okay.
So the Residential Tenancies Board in that particular situation said, no, we can't give any protection there, you have no rights. But you never know. And the Residential Tenancies Board, they favour, well not favour, but I mean certainly some of the decisions have favoured the tenants, and it's difficult for landlords at the Residential Tenancies Board,
Okay. Because I think they do is try to comply with the UK regs, so might be 12 square metres with an ensuite built in, so none of that changes anything. It's kind of is self-contained, even though there's shared kitchen and amenity, and there's certainly a risk.
Well, we used to have a situation here where we had bed sits, especially in Dublin, and on the North Circular Road and the South Circular Road with the big red brick buildings, on those two roads.
Yeah.
But we had the bed sits where, older people, maybe single men working at the buildings, like shared bathrooms and accommodation, or shared bathrooms and so on, and they had relatively cheap accommodation. But that was done away with a few years ago there because there seemed to be some standard or whatever, and exploitative, and people should have their own bathrooms or kitchens and so on. But they probably served a bloody purpose at the time,
It was probably a
and maybe as well. And now, but they always change to do away with them or to outlaw them. So
I think the big problem with them at the moment is mainly they're affecting the people's immunity. So you have to go, obviously, if you have 12 people in a house, it just maybe only fit 4 or 5. There's additional parking spaces and whatever. So that needs to be considered. But what about things like the derelict and vacant property stuff, for the grants and all that?
Yeah, a lot of people, as I was saying earlier, have come from the UK, and a lot of them have done so with a view to doing up places, derelict properties or vacant properties, and perhaps getting the money from the local authority, that local the vacant property to derelict property grant. Now, the problem is, the problem at the outset is it only suits cash buyers essentially because you need to spend the cash up front. So if you're a young couple and you like a cottage in, your parish or the next parish, it's not going to suit you because if you're a young couple, you have to borrow from the bank and it's simply not going to happen. You can't avail of the grant from the local authority because you don't have the cash to spend on the place.
Yeah.
So that's a bit of a chicken and egg situation. So in theory, it's a good system, a good grant scheme, etc., etc. It's generous in theory, but in practice, I haven't seen that many actually going through successfully. And I think the data on that is pretty abject as well, to be honest about it. In other words, of all the applications, like there's been a very, very small few who have actually got through and got the bloody money,
Okay.
So it's a good scheme in principle, it's a good scheme in theory, but in practice, it's difficult.
Haven't they just brought in there, is there a loan that helps you to actually get to the grant status?
If there is, no, I'm not sure about that.
Yeah, that probably reflects what I know that as of say 6 months ago, there was only a handful of completions.
Yeah, it was absolutely. Yeah, the scheme was in maybe a year, 2 years, or whatever at this stage. But we've seen a lot of people making inquiries and so on and so forth, but actually spending the bloody money first and then getting the guy out from the local authority to check it and so on.
Yeah,
and then getting the money is just difficult. So
getting those properties up to the necessary standard as well,
even though there could be money pits, there could be money pits. Do you know what I mean?
Yeah, things like obviously you see a lot of underpinning in those old buildings as well. You don't know what's in the ground, and then even though you can combine it with the SCAI grant, it's whether it's cheaper to knock them down and start again. I don't know.
Exactly, yeah, but if you knock it down and start again, you're not getting the grant from the local authority. You know what I mean?
Yeah.
So all you're buying is a site then. So
yeah, I just wonder if it still stacks up to try and refurbish it. So I suppose every one of them's different, but so just going back to the developer stuff, a big part of what I do would be working with SME developers, maybe looking at, I don't know, taking on small sites, maybe a bundle on a large site or a corner plot or an infill site. What's the big risks you see with those type of sites? Like things like, do you see much restrictions on titles, that type of thing, to prevent that?
the title is okay, but the planning is the bigger problem. And the time involved between getting plans drawn up, getting them submitted, and then maybe responding to further information requests from local authority, and then perhaps dealing with objections.
Anyway, that's plenty. That was really,
it's great, love stuff.
Thoughtful. If people looking to get in touch or need any assistance with
just saying the website, or else Google my name online and they'll come across me, or else my YouTube channel, probably my website, businessandlegal.ie, or just Google my name, Terry Gorry, and they'll find me.
Okay, yeah. Thank you.
All right.
Okay, perfect.